Right.
Okay, I give the host over to you.
Fine.
And then just check you can share screen.
I will indeed. I will share the screen. You are the host now. Let's see.
No, you are.
You are.
Yeah, I gave
I
it
am.
over. Yeah, you, Prof Sinclair, you are the host.
I'm the host, and I seem to have the document up. Can everybody see it?
Yes.
Okay, Shmuley, can you see it?
Yeah.
Fantastic. Okay, we have another minute and we'll go. All is well with you and your family, Yael?
Baruch Hashem.
We all hope for good news,
Yes, we
brighter
do.
times, and very soon a ktiva v'chatima tova.
Thank you.
As they say in French, a good gebencht Jahr.
And do you see French?
Par unser und par alle Klal Yisrael.
Amen.
Oh, mine.
Amen. Amen.
And we're going to talk about ameliorating the plight of the aguna. Something positive, perhaps. Prenuptial agreements, PNA. So one more way, we've looked through quite a few ways of doing this. And we're now going to conclude. And we're going to talk about some very recent developments. One is the prenuptial agreement, the PNA. Now, this idea actually started in Morocco with Harav Shlomo Messas. He was the chief rabbi of Morocco. We'll talk about chief rabbis possibly next week. And the Moroccans were fairly progressive, and they were a French protectorate, and civil marriage was available. So Jewish husbands could become civilly married and civilly divorced and not care about their wives receiving a get. This, of course, again, is very prejudicial because the wife who thinks that she has a get will go off and have a liaison with another man, bring children into the world, and they'll be mamzerim. So what Rav Messas did was to design a document to be signed at the same time as the ketubah. In other words, at the wedding. And what this document said basically was that the husband commits himself under the chuppah, before the chuppah, under the ketubah, to provide his wife with a certain amount of maintenance. This is a biblical obligation. Husband has to provide his wife with food and clothing, and of course, sexual gratification, but food and clothing and money. Now, rarely, if at all, is the money actually agreed. It is understood that the husband will do his best depending upon the financial situation in which he and his wife find themselves. But what Rav Messas said was, let's put a sum that the husband agrees to pay his wife for her support, quite a serious sum. But the same document will say that the wife agrees to waive that sum and to rest content with the money that is brought in, whatever it happens to be. However, should they live separately for, say, 6 months, then the agreement, which is a civil agreement, a contract, will kick in, and the wife's waiver will be nullified, and the husband will then have to pay the agreed maintenance at the time of the wedding until he gives her a get. Now, Rav Messas eventually became the chief Sephardic rabbi of Jerusalem, and he met the Ashkenazim here, who were a tougher lot, and they weren't particularly happy with this, but they gave it a couple of tweaks and said perhaps it may be possible, okay? And basically that's where it stood. It was discussed in halakhic circles, and it may be that some Sephardic rabbis would have issued such a document, but it was done rarely, if at all. In recent decades, the PNA has come back with a vengeance in modern Orthodox circles, modern Orthodoxy. And the idea is exactly the idea that I've just explained as coming from the Moroccan Rabbi Rav Shalom Massas. What happens today in America, Europe, here in Israel, couple agrees that at the time that they're getting married, they will sign yet another document of a civil nature. Ketubah is a civil document. This is a civil nature, of a civil nature contract. And the contract will talk about the fact that the husband agrees to pay his wife a certain amount of money in support. That amount of money will be waived. The wife says, I don't mind. Good evening, Jack. If we do not, if I do not get that amount of money, but if we live separately and I'm interested in getting a get, okay, or just if we live separately, 6 months, say, then that waiver will be cancelled and the husband signs on this. And I agree to start paying the large sum of support that was written down in the PNA, the prenuptial agreement. So it's really a civil agreement. I mean, PNAs are used all the time, not only in Jewish circles, but in non-Jewish circles. People want to arrange their finances when they get married, especially if it's a second time around and they all come with their financial resources. And so it is a civil contract. And if the husband defaults, he can be sued. And of course, the sum should be a serious sum in order that the husband, when faced with this PNA, will say, okay, you know what, I am going to give my wife the get. It actually works both ways. And the documents we draw up today in Israel, the USA, in Europe, they cut equally for the wife and for the husband. But of course, in these cases, the overwhelming majority of recalcitrant or stubborn spouses are husbands and not wives. So this is the idea behind the PNA. And as I said, it's used today by modern Orthodox couples. The RCA, the Rabbinical Council of America, insists that if a rabbi belonging to the RCA is going to be a Masadeh Kedushin, then he has to have such an agreement signed by the bride and the groom. So there's no question there. Europe, it's a matter of choice. Israel is clearly a matter of choice. Now, as I said, in America, it is pushed certainly by the Bet Din of America as being the gold standard at present for dealing with the Agunah situation. In other words, this document is meant to be both morally coercive. In other words, husband signed on, he has to honor this agreement. And also the people who tend to sign these agreements are people who would normally respect each other. The Haredim do not sign on PNAs. And the funny thing is, one of the arguments, main arguments that the Haredim use is, it's funny because they say, on the day of our wedding, should we start thinking about divorce and me not giving you a get? All this is going to put a terrible blight on the wedding. It's a funny argument and rather silly because why? Somebody unmute and give me the answer. Why is that a silly, spurious argument?
Rabbi, comment il s'appelle? Ovadia Yosef said once it's better to cry before than later. I would give this answer.
Okay, I'm not sure that you're answering my question. You're coming later. My question was, why is this a silly argument that we shouldn't be discussing divorce on the day of the chuppah? What else do we sign on the day of the chuppah?
The Knoim Acharonim is
The Ktubah. And what is the Ktubah?
Says also
Talk about?
It's a contract.
Yeah, about what?
The Ktubah is less because the Ktubah says that anything he has, the best guarantee.
Correct, but what is it talking about? Avi, what is it talking about? The Ktubah talks about what? Unmute.
A divorce.
Divorce.
Mm-hmm.
So you're signing on this holy ksuba, okay, that everybody makes a big fuss of. It's a totally civil document, only giving the wife a financial insurance policy in case the husband dies before her, or if he divorces her, it's not her fault. So what do you mean you do not want to talk about divorce or death on the day of your wedding? In fact, it's a very good thing because you're being responsible. You're taking responsibility for a real situation. So, of course, this is a good thing to do. And to say that we are bringing in terrible thoughts about the breakdown of the marriage on the day of the wedding is ridiculous. But if you don't want to get involved in anything untraditional, if you're a Haredi, then of course, that is what you'll do. But there is actually, and Jean, you will know this, a different argument that is made by the Dayanim here in Israel on the rabbinical court. So they say that PNA is a good thing for America. Why? Because in America, there are no Batei Din that have power to either put men in jail if they don't divorce their wife, or to deprive them of state benefits, indirect coercion, as we learned last time. But here in Israel, we have Batei Din, and therefore we don't need PNAs, we don't need anything over and above the traditional Ketubah, and there is a resistance on the part of the Haredi rabbis, certainly, or even of the rabbis of the regular Batei Din and Rabbanei Ir to actually draw up and sign on PNAs. But in modern Orthodox circles, it is certainly done, and one can do it with a lawyer. You do not need a rabbi at all. You can also go to the court, and the court will draw up a PNA, and in certain circumstances, you can even do it after or within a short time of the wedding. So the PNA is a powerful instrument, and everybody should make sure that when their, I should say, probably grandchildren get married, that there is a PNA there, because statistically speaking, it certainly helps. And even if the effect may not be fully legal, because a civil court might say, well, actually, you want to get me involved in the get proceedings, which I don't want to be involved in. It has a moral force. And here it may very well in Israel fall within the rubric of financial agreements between spouses, which is a form of contract recognized by statutory law in a law from 1974. So I hope that's clear. And you can go online, you can read about the PNA, the halachic PNA, you can read about the Heskem le Kavod Hadadi. It has a nice name in Hebrew, the agreement for mutual respect. Okay? Or other terms as well. But let's have a look at the next, line 9. So who would like to read? My first English reader is Jack. You're on, if it's okay. Tort suits.
Tort suits before secular courts for pain and suffering caused by get deprivation in the diaspora and in Israel, the problem of mistaken get musar.
Okay. If you can come closer to the mic, that would help. They will hear you more loudly. Now, what is it? What are torts? Torts are the laws of damages. In other words, I come to court and say, so-and-so caused me damage and should compensate me for the damage caused. Now, the law of tort extends to emotional harm as well. It started out in the 19th century in laws relating to what they call nervous shock. And somebody was exposed because of somebody else's fault to something that was really horrible and shocking and suffered mentally. So here a woman comes and says, I've been deprived of a get by my husband, terrible man for many years. I need to be compensated for the emotional suffering, for the loss of self-esteem, for the cruelty, for all the terrible things that nasty men can do to their wives. And it works. It is recognized both in the diaspora, in the secular world at large, and in Israel. It took a while, but certainly, again, the recent period has seen the advent of tort suits for get deprivation. an interesting point that I'm going to make, and this will take us into some responsa in in what is known as the Vienna get. The problem of mistaken get mut'eh. Now
What does it do here?
we've talked about mistaken marriage, and we talked a lot about that. But how about a mistaken get? Well, how do you make a mistake when you give a get? I mean, the only mistake can be that of a husband. Husband makes a mistake when he gives a wife a get. What does that mean? Well, if we analyze the sugya, it means a fundamental error. In other words, husband says, I thought I was giving my wife a birthday card, but it turned out I gave her a get. Okay, I'm not going to go into how that could have happened, but there we are. Stranger things have happened. So this is the get muteh. I really thought it was something entirely different, and I made a mistake, and now I regret it. I want you to cancel the get. Then the get is canceled because it was given under an entirely erroneous impression. Now, I'm going to take you to the 16th century. It's not written on the sheet. This is going to be just me talking here. The 16th century to, well, actually the beginning of the 17th century. It's the year 1611. We are in Vienna, and a young man comes to the Av Bet Din, Rabbi Manoach Hendel of Vienna, and says, I had a terrible thing happen to me. I was married to Batsheva, the lovely and charming daughter of a wealthy family, and then I became seriously ill. Now, my doctor said, and this, of course, was somebody who lived in Poland. He actually was a native of Lublin. My doctor said, I've got to go to Germany for a cure. The only place that I can be cured will be in Germany. So before he went off to Germany, the wife's family, who didn't like him much anyhow, said, you know what, do the decent thing. Give your wife a get. If you die in Germany, then we'll have to prove that you're dead. And then you have a brother and you have no children with Batsheva. So she'll need to get chalitza. Your brother's a difficult customer. We know that. So why don't you do the right thing? Give her a get now. Then if you die, she doesn't have to suffer at all, at least in terms of having to get chalitza. And if you come back alive and well, you can marry her again. No problem. You're not a Kohen. Okay? So the young man was persuaded and he said yes, and he gave her a get. But the only reference to the condition that when he comes back hale and hearty and healthy, then he will be married to Batsheva was oral. It was not written. There was no written agreement to that effect. Well, our young man goes to Germany. Operation is a great success. Comes back after recuperation time and asks Batsheva to come and get married, remarried, as they agreed. The families say, no way. We're not going to allow her to marry you. You're divorced, go away. But it so happened that the young man's great uncle was the Maharam of Lublin, Rabbi Meir ben Gedalia of Lublin, who was the posek of Bet Din of Lublin. And he was a halachic heavy. And when a member of the family is badly treated, then the family members often weigh in. So the Maharam of Lublin gets involved, and he says, this was a get mut'eh. My great-nephew gave a get on the understanding that he would be allowed to remarry if he came back healthy. And look, you are not allowing him to remarry. Condition is broken, and therefore he gave the get under a fundamental error, and the get is not a valid get. Get mut'eh. Can we have everybody who's not speaking muted?
Danny,
Please?
you can mute everybody. You're the host.
I can mute everybody, okay? Where is my mute button?
Can't see your screen from here, but it's somewhere where the controls are.
Somewhere where the
It
controls
says
are.
mute all.
Show. Hi. Thumbnail video. Show grid. Video, let's go down here.
And people can still unmute themselves, but you can mute everybody in one go.
Okay. Let's see. I've got a deficient screen.
No, in the
here.
meantime, it's quiet.
Okay.
Mute A.
Mute. I don't want to mute myself. Can you still hear me?
Yes?
Okay, so we'll just go on as we are, and I'll try and get a fuller screen in the course of my time or not. So the Maharam of Lublin steps in and says, get muter, the get is not a valid get. And my great nephew and Batsheva of the wealthy family are still married. Well, then all hell breaks loose in halakhic terms in early 17th century Poland. The rabbis line up, okay, because Rabbi Hendel, who signed on the get together with the Sama, the Sefer Miratei Naim, Rabbi Falk Katz, okay, wrote the Sefer Miratei Naim on Shulchan Aruch, was no lightweight, and he said, nonsense, get muter is only when you don't understand that you gave a get. If you attached a condition to the get that wasn't honored, that's not a get muter. That's simply a condition that wasn't fulfilled, and there's no way that you're going to abrogate and nullify a get. And he gave two reasons. I'm collapsing 36, 37 different shuvot into 3 seconds, okay? The two reasons were, one, whenever you give a get, you sign on something called bitul tanaim. Every time a husband gives his wife a get, he signs on in front of the bed called bitul tanaim. He nullifies any conditions he may have had in mind or he may have written up in terms of a get. We don't want conditions hanging over a get. Ein tanai begitin. Otherwise, the wife would never know if she has a get or she doesn't have a get, and we always avoid that. Number two, we have a rule in the Gemara, en motzi'in laz ala gitin. We do not say that the get is an invalid get unless we really need to. Laz, of course, is saying that it's not a valid get, because we have to be really careful here. So the Sama and Rabbi Hendel, and then a whole slew of famous Polish authorities, the Maharsha, Rabbi Shmuel Edelis, Maharsha in the Gemara, the Bach, Rabbi Yod Sirkis, Binyamin Selnik, the famous Mas'at Binyamin, and the Bet Shmuel, Rabbi Shmuel Fivish on the Even HaEzer, the Kliakar from Prague, Rabbi Ephraim, Lunchitz, etc., 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 all signed on. A few poskim sided with the Maharam of Lublin because they were his mates, but the majority held that the get was a valid get, okay? And what happened was that the issue went before the Council of Four Lands, twice. Council of Four Lands, the Vad Arba Aratzot, Poland, Russia, Lithuania, and the Pale of Settlement was operative at the time. And major matters were discussed. The Vienna get came up twice, and the rabbis and the lay leaders all decided in favor of the majority. But the Maharam of Lublin held out. And
Is there no Indian of being Nogea Badova? If it's a family member, you can't paskin in such a thing?
Well, it's not very clear, because
It was the
the
family
Jewish
of the wife.
communities in general,
No, the
people knew
Maharams
each
were the family
other,
that
and they were related to each other.
Through the wife.
And if you had what we call a bet din chashuv, you had an important bet din in a city, the Dayan could very well say that he was not affected by the relationship at all. Okay? It didn't work. It's far cry, as we'll discuss today, from the way that modern courts of justice proceed. Okay? Everything was much more flexible, as they are in Bate Din today. the more frum, the more flexible they are. And therefore, as we know, and therefore we have an interesting confrontation between standards that are set by non-Jewish authorities in diaspora countries and the way Orthodox Botei Din actually work. And we'll talk about that too. But the point is certainly well taken. You shouldn't be judging a close relative, certainly not. But other than that, Jewish law is very flexible, okay? So the Maharam, anyhow, wasn't actually, well, he was making a psak, but he was saying, look, this is halakha. I can write an opinion, and all psak is an opinion, okay? I'm writing an opinion, and I think that this is the correct response to the get of Vienna. He was overruled twice, and because of the get of Vienna, eventually, the Council of Four Lands made a recommendation to Lublin, and he was forced to resign. He was no longer the Av Beit Din of Lublin. So we have ways and means of doing things. But the interesting thing is that tort suits in Israeli courts is a fairly recent phenomenon. And as soon as it started to happen, the Dayanim of the Batei Din Rabbanim said, if you go to a secular court and my husband has been damaging me emotionally, has caused me terrible harm, okay? And I want thousands of shekels as compensation. And then say the husband says, oh dear, well, if you're going to go to the court and sue me, I'll give you the get. Maybe a get mut'eh. If the wife, after she gets the get, goes to court and says, now you're going to pay me as well. You get the point? A woman in Israel could tell her husband, you know what, I'm going to sue you. And you can, because now you can sue for get deprivation. So the husband gets very nervous, gets the lawyer's letter, maybe may have to go to court. And so he says, you know what, you want to get, right? I'll give you the get. She says, wonderful, make an appointment. We'll go to the Beit Din Rabbani. He gives her the get. Then the next day she goes back to court and says, okay, let's continue with her suit and continue suing him for thousands of shekels. Now, in relation to such a situation, the Batei Din Rabbanim say, well, we will apply get mut'eh here. And we will say that if the husband continues to be sued, then the get that he gave will be considered to be a get mut'eh, because he gave it on the understanding that his wife would not continue to sue him, and therefore the get will be an invalid get, and she will not get the get. Okay? Then it's up to her. Of course, the question is that analysis halachically correct? Is it a get mut'eh? Or is it similar to the Vienna get? In other words, it's a condition. Okay, the husband attaches a condition to his get. I'm giving you a get on condition that you withdraw your tort suit. She doesn't. Does that make the get into a get mut'eh? Everything we know about get mut'eh in the Gemara says it has to be a fundamental error. You thought you were giving something else instead of a get, not a condition, as we learned in the view of the majority in the Vienna get. Because we want gittin to be as boilerplate, as cast iron, as we possibly can. So this is just a reflection on what is happening. Jean, I think you've gone into this, if I'm not mistaken, why Israeli rabbis, first of all, object to the P&A, but I don't know whether you went into the idea of tort suits as well, but the idea of get mut'eh. So if you have a comment, now is the time, but loud and clear, please, and close to the mic. Jean.
Yeah, I don't remember exactly, but I think that I wrote that this is the reason why we should always end all the financial things before, first give the get and then discuss the financial aspect. to avoid such a discussion.
Okay. First of all, you have to come closer to the mic or speak more loudly. But second of all, I think that may be a different issue again. Okay, that husbands, the Seder Aget, the Ramaz Seder Aget in Even Ezer says that in order to have a get accomplished successfully, you have to have all the financial arrangements in place before the get is given. That, of course, gives the husband leverage. He can delay. He can simply say, we're arguing. We can't agree over the house in the Hamptons, the villa in, I don't know, in Adelboden. We cannot figure these things out. So he never gives the get. But today, so even in the past, there were batei din, and there are tshuvot that in serious cases, you can ignore the Seder get in the Shulchan Aruch, and you can give the get before. And the Bet Din of America, for example, is very well known that it does this. It will insist that the get is given and then deal with the financial aspects. And there are batei din in Israel, depending upon the dayanim, who will also give a get, arrange the get to be given before all the financial aspects have been concluded. But as you can see, there are
And that's one,
complex.
sorry, yeah, that's one of the conditions of the Israeli PNA also, that you don't have to finish all the financial arrangements before the get is given.
Thank you, Debbie. So Debbie has informed us that the PNA in Israel also contains a condition that the get will be given before the financial issues are resolved. That's very important, Jean, as a practical thing, because one of the things that nasty husbands do often is to delay, because they say we haven't got as against that, the Seder Get in the Ramah on the Shulchan Aruch wants to say that a get should be given without any strings attached. In other words, we want to know that when the get is given, there's nothing hanging over, okay? Because the get needs to be a get, so that the children of a next marriage are not mamzerim, and there's no question. But
because they are afraid that they will have contact
practically
together.
speaking, we go ahead today more and more with having the get, and then we sort out the financial arrangements. Good. So that's a little about get mut'eh, a little about tort suits, and that's something else. But of course, it's sad to be in a position of a tort suit, because you'd only bring it if you had been deprived of a get for a number of years. The suffering is great. And
Isn't today the custom, especially in Israel, to give when a man gets off into the army, especially during time of war, to give a get al pi t'nai?
A lot of women didn't want that because chas v'chalila, the husband should be killed. It's better to be a widow than to be a divorcee.
Yeah, but she doesn't know if the husband is killed or not. That's the problem.
Well, but today, we don't have people who have, I mean, mostly, but there was a move to do that, but it was basically dismissed because the women didn't want it.
I think I can just expand on that, Jack. In the past, you're absolutely right. All the wars, First World War, Second World War, the Israeli War of Independence, it was a done thing for soldiers to give their wives a get because they may have gone missing in action, never found, and the wives will be agunot for the rest of their lives. But as Debbie said, there's been a change, and we now know, really, we have a lot of information, and we have ways, and I think we may have gone into this or not, but when husbands are missing, even say in the Twin Towers or in the Dakar submarine or Ron Arad, we can, halakhically speaking, declare them to be dead. And in fact, what happens in Israel is, as Debbie just said, very practical, because she works in this area, okay? In Israel, if you are a war widow, you get a lot of benefits and your whole status is very special. But if you're divorced, you don't get the financial benefits, you don't get the state support, you don't get the social support. It's a whole different thing. So, Jack, you might want, in fact, to stay married rather than use what we called gitei milchama, war gittim. But in the distant past, where many of us still belong, the idea of a war get was certainly used all the time. British Army, Israeli Army, American Army, and all over the Jewish world, rabbis would issue such gitei milchama. Okay, Shmuley, can you read number 11, please? Decisions of the Rabbinical Court.
Tzvat.
But you're muted.
The decision of the Rabbinical Court in Tzvat 2014 in relation to a husband in a persistent vegetative state, PVS. The Beis Din gave the get on the vegetative husband's behalf, using the concept of constructive agency get zikui.
Vegetative stuff.
Okay, very good.
What does it mean? That it was the volunty of the man to do that?
I'm now going to explain what get zikui is, okay? And we're going to start by making sure that we know what PVS is. What is a persistent vegetative state? Brian, we can ask you.
Okay, so I think we have to say what it isn't first.
It's
And
your call.
And it is not brain death.
Good. Did everybody get that? Not brain death. So you're still
We're
alive.
dealing with PVS is a state where the person is unconscious, unable to communicate, but retains certain brain stem functions, which means, for instance, that they may well be able to breathe without being on a ventilator, as opposed to brain death, which is a severe condition of the brain stem, where, for instance, if you remove the ventilator from the person, that person within minutes would be dead. But the important difference, which you're going to explain it, but I might be a little surprised by this, the difference between brain death and PVS, to my certain knowledge, as having done, as you know, a lot of heart transplants in the past, and being careful with who I perform a transplant on, to my certain knowledge, no one has ever recovered from brain death, properly performed tests for brain death. Recovery from PVS is extremely rare, but it does happen. And that's why I might be a little surprised at that ruling.
Okay. So let me see. I have all sorts of things have been happening on my screen. Can all of you see the screen share?
Yes, nothing has changed.
Nothing has changed. Okay. It's just mine. All right, fine. We're in Tzfat in 2014, and a husband is brain dead. Okay, he had an accident.
Hang on.
It's not
Brian
brain
just
dead,
said
that's
it's not
PVS.
brain dead.
No, he is
PVS.
PVS. I'm just clicking away here, but I'm getting no response. All right. He is he is in a persistent vegetative state. So
And that's important.
legally speaking, he's not capable of doing anything. Okay. So can he give his wife a get?
No.
No, because he can't do anything legally at all. Okay. All he's got is his brainstem, and all he can do are what we call vegetative functions. He can breathe, his heart beats, he responds to light, there are sleep-wake cycles, and there are digestive juices, but nothing else. But if you will keep him reasonably clean, give him some basic nutrition, move him around a bit, and if he's young, as this man was, you could keep him going for quite a few years. So, what is to be done? His young wife may have a child, is now condemned for the rest of her life to be an aguna until her previous husband actually dies.
Or wakes and they don't know if he will.
Yeah, but as Brian just said,
Yeah,
these diagnoses are usually very sound. Okay,
yeah,
rarely are they wrong. And the longer it goes, the less likely that somebody's going to recover. We like to think about those things, but often they're just fantasies. So, Rabbi Uriah Lavi of the rabbinical court in Tzfat decided to do something very courageous. He is a regular yeshiva-trained Haredi type Dayan, as they are all in Israel. But he is a great expert on the laws of divorce. And his book on Hilchot Gitin, probably the magnum opus of all books on Gittin. So he suggested the following. We have a principle in halakha called Zachin la'adam shelo befanav. We can do something good for someone, even if they don't know that we are doing it on their behalf. So let me start with a very simple example. I find a 200 shekel note or $100 bill, we'll make it more dramatic, on the footpath, okay? And I say, in front of two witnesses, this $100 bill is going to belong to Debbie Sinclair, okay? Now, at that instant, the ownership of the $100 bill passes to her. Of course, it's a $100 bill that is hefker. I found it in a public place. There's no way of identifying it. Don't have to return it as a lost article. So I can be mezakeh. I can pass the ownership on to Debbie. Now that's clear. That's in civil law. But can we apply it to family law? Well, here we do have one illustration, and that is in the area of conversion to Judaism. Can we convert a small baby to the Jewish faith? A Jewish couple, say an Orthodox Jewish couple, adopt a non-Jewish baby, okay? Can they convert the non-Jewish baby can they convert the baby into the Jewish, make him a Jew? Can they do a giyur? Can they do a conversion? Well, again, you might say, well, for any legal change in your status, you need to have consent. And you certainly need to be able to understand what's happening. And we're talking about a katan, a minor. Now, a minor can only be acted on, we can only act on his behalf through an agent, through a guardian, through a natural guardian. So we have a problem here. And yet we do say, and the Gemara says, we can convert a minor on the basis of what? Zachin la'adam shelo befanav. Lo befanav doesn't mean not before him in a physical sense, because the baby is here. But it means that intellectually speaking, rationally speaking, in terms of legal competence, the baby cannot say, yes, I want to be Jewish. Okay, I will leave the faith I was born into, whatever it is, and I'm going to become a Jew. So we say, Zachin la'adam shelo befanav. It's going to be a zechut. It's going to be an unmitigated merit, a good thing for a baby brought up in an Orthodox Jewish home to be an Orthodox Jew. Otherwise, there'd be inconveniences all the time. The Gemara, however, does say that we do, as it were, pay some credence to the idea of having made the baby a convert, even though we made the decision and not him, by saying that when you reach the age of majority, when the katin or ktana become 13 or 12 respectively, they have an opportunity to reject that conversion. They'll say, well, now I'm of sound mind and adult capabilities in Jewish law. I really don't want to be Jewish. However, it isn't done formally very often. And many rabbis and poskim will say that the fact that you consent to have a bar or bat mitzvah, as it were, without you having to say so, means that you retroactively validate your conversion as a baby. So we do have then this idea of Zachin la'adam shelo befanav in the case of family law. But that's the case of conversion of a minor. Do we have any other cases in the Gemara where in family law we use the principle of Zachin la'adam shelo befanav? Well, the answer is that we do. and it occurs in relation to divorce. But note, what happens in the case of a husband who knows he's about to die? Say he went to climb Mount Everest, and as unfortunately it does happen, he was caught in a storm because he insisted on getting to the summit, and they said there's a storm brewing, but he said, I'm come all this way, I've got to get there. And by the time he's ready to descend, he finds himself in deep trouble. He's going to die on the mountain. And he has a very problematic brother who is a deep sea fisherman in Alaska, who nobody has heard of or seen of for many years. And if he dies, his wife will need to get chalitza from the brother before she can remarry. They have no children. So what does the husband do? He organizes witnesses and a scribe and all the accoutrements of Jewish divorce proceedings on the peak of Mount Everest, and he appoints his shaliach to accept the get on behalf of his wife. Now, the wife doesn't know anything about this, and you're appointing a shaliach on her behalf. Normally, if you want somebody to appoint an agent on their behalf, they have to be fully cognizant of what is happening. Cannot create an agency just because you or a bet din say so. Agency has to be properly created with full intention on the behalf of the principal to make the agent a valid agent. But in this case, says the Gemara, we're allowed to do so, and we use what I might call a constructive agency. We create an agency because we say the wife will appreciate having this get because it enables her, after the tragic death of a young husband on Mount Everest, to be able to resume a married life should she wish to do so and have children without the specter of the get and mamzerut hanging over her. So zachin la'adam shelo b'fanav, it is an unmitigated good, and we can apply the principle even to a case of divorce. Now let's get back to Rabbi Uriel Lavi and the Sfat get case. Rabbi Lavi said, husband, PVS, is in no way capable of any legal action at all, certainly not giving his wife a get.
I
But
think
either get did.
you should just mention that this was 7 years already that he was PVS.
7 years PVS, but he was a
Yeah.
youngish man and
Yeah.
could go on for another 27 years. Correct, Brian? If you're young, PVS can go on for a while.
Yeah, absolutely. But I think the point that your wife was making was not how
Medical,
old
but
or young he was, but
sociological.
whether what the chances that he'd already had 7 established years of PVS, and therefore maybe the chances of recovery had become from slim to very slim.
And
Thank
she
you.
was suffering.
And Debbie wants to emphasize the suffering. You want to emphasize the diagnosis. I want to emphasize the sociology. Shivim panim Torah. It's great. Okay. Whatever the case may be, Rabbi Lavi felt very strongly that we must do something. We must do something in this case. It is no longer possible to tell women in this situation, we're very sorry. Halakha is impotent, cannot do anything. You'll be an aguna for the rest of his life, and it may take a while. So Rabbi Lavi said, let's apply the concept of zachin la'adam shelo b'fanav to this case, and we'll say as follows. The husband would have wanted his wife to be free to marry and to make a life for herself with her young child. So it is an unmitigated benefit for him. But more than that, every day that the husband is in PVS, he's not fulfilling 3 mitzvot in relation to his wife. What are these 3 biblical mitzvot? They are exactly. He's commanded to supply her with food, with clothing, and sexual gratification. He can't do it. So is every day that he is in PVS a day of 3 sins at least? Of course he wouldn't want that. So a combination of loving his wife, and there's no evidence that there was any breach between them before the accident, and the fact that so his natural sympathy would have been for her and to allow her to start again, especially since 7 years, thank you, Deb, have passed, and the fact that he is in breach of 3 mitzvot midoraita every day, and there's very dati couple, a very religious couple. Let's say that this is an unmitigated benefit on his part to have the get given by the Bet Din, and I'm going to call this a constructive agency. He is appointing the Bet Din as his shaliach to give a get. A man can appoint a shaliach to give a get, as we well know, because we talked a lot about it in annulment of marriage, and we can create if you like, an unintentional agency on the husband's part, and we can give the get on his behalf, even though he is out of the picture. Now, this is a revolutionary step, because bear in mind that the whole essence, or the entire essence of the rabbinical approach to a get, is that the husband gives the get to his wife. So even in the case of the Gemara, on the young man trapped on Mount Everest and about to die, he can give the get. We appoint a shaliach on the wife's behalf, even though she doesn't know, but it's not such a terrible thing. He gives the get. But here, when he is no longer in the picture, and you, the Bet Din, are stepping in, when there's no husband, and you're giving a get, on the basis of Zakin La'adam Shelo B'fanav, it'll be an unmitigated benefit for him. That is a revolutionary step. And this is why the psak was given, and Rabbi Lavi immediately got into a lot of trouble. The halakhic authorities stepped in, they criticized him very strongly, and went as far as having somebody hired to appeal the decision of the Tzfat Bet Din to the Supreme Rabbinical Appeals Court in Jerusalem. The Supreme Rabbinical Appeals Court. Now, as soon as the news of the appeal came out, an issue arose, because the rabbinical court regulations, all rabbinical courts have to adhere to these regulations. They say that if you want to appeal to a rabbinical court, you have to show a strong connection to the case. All law, of course, has such a concept. It's called standing. You cannot appeal a decision because you read about it in the newspaper on your morning trip on the tube to the city, and you felt strongly, and you go to court and say, I want to appeal. Of course not. You have to show that you have a strong connection. In America, they have amicus curiae briefs, which is a special concession that people who are not very strongly connected, but have an ideological or a political or a social angle, can ask the court to consider an opinion, but certainly not an appeal. And this Mr. Cohen had no connection at all. All he said was that he felt deep sympathy for the husband who's been deprived of his wife. It's not a benefit. He's no longer married. Terrible thing. Okay, PVS, not married, but still. So therefore, he wants to appeal. Well, of course, the High Court of Justice, the Bagat, the secular court, can intervene in a rabbinical court decision, not in relation to the actual content of the decision, but whether the decision has been made in accordance with its jurisdiction, whether it's overstepped its jurisdiction. And here, the argument made before the secular High Court of Justice was that the Bet Din Rabbani, Supreme Rabbinical Appeals Court, okay, is hearing an appeal against a decision of a district court in Tzfat, and the appellant who's making the appeal has no standing. He has no connection of any fundamental type with the case at hand. Now, the High Court of Justice sends an order to the Rabbinical Supreme Court to explain how it can hear Mr. Cohen's appeal when he has no standing,
Connection.
no connection. Well, the answer is, according to the Rabbinical Appeals Court, at Shuvav the Marashtam, Rav Shmuel
The Medina.
Medina, the famous Turkish Balkan authority. He lived in Salonika, Rosh Yeshiva, one of the most prominent rabbis of his time. The Marashtam was asked a question, again, Tshuvot, was asked a question from Egypt, actually, where a man who refused to give his wife a get in Salonika had gone to Egypt on a business trip. And the Beit Din in Egypt had intervened, and they were threatening him with various indirect measures if he didn't give his wife a get. The husband then complained and said that the Beit Din in Egypt has no jurisdiction because it has no standing. It wasn't involved, it knows nothing about the case, and therefore it should butt out. Has no business intervening. Then the Marashtam cites a famous principle that when it comes to agunot, every Jew anywhere in the world has standing to come before a Beit Din Rabbani and argue the case. And therefore the fact that Mar Cohen, that Mr. Cohen has no connection, doesn't matter. It's an agunah case. And therefore any Jew anywhere in the world has standing. What's the flaw in this argument?
They only have standing on behalf of the wife, not on behalf of the husband.
Because here is not to help, he wants to condemn.
Exactly. So it's, again, it's almost pathetic. The greatest halachic minds, apparently in Israel and the Supreme Rabbinical Appeals Court, think they can send a reference to the secular Bagatz that the secular Bagatz will not understand and will agree that they have standing. Don't they know that on the Bagatz, on the Israeli Supreme Court of the time, there's always a judge who's an expert in Mishpat Ivri or Jewish law. At the time it was Eliakim Rubinstein, who's a lot of halakha and looked and knows the Marashtam very well, and he wrote back a scathing reply telling the Supreme Rabbinical Appeals Court not to be so idiotic, that you can have standing to free an agunah, but certainly not to chain her. And in 30 days' time, unless he hears a coherent reply from the Supreme Rabbinical Appeals Court, and this was apparently Rabbi Yosef's instigation, he is going to declare the appeal invalid and it will not be heard. 30 days passed, of course, the Rabbinical Supreme Court Appeals Court had nothing to say, and nothing was done. The get is a get, and the woman was given a heter nesuin, permission to remarry, by the Tzfat Rabbinical Court. Now, the story doesn't quite end there. Turns out that Rav Lavi had actually been working on this solution for agunot for a while. But he was very careful to say that this solution is only for agunot of the type of PVS, or perhaps we could say serious mental disease. And I could talk about the get of Klev, which involved how insane a husband has to be, okay, before he's no longer able to give a get. But Rabbi Lavi thought that this get zikui would help in these cases as well. He didn't want it to become a standard solution for agunot, but only in this type of case. So he broached the issue with two gedolim, Rabbi Zalman Nehemiah Goldberg, Hagarzen, Hagaon Reb Zalman Nehemiah, Hagarzen, and Rav Ovadia Yosef. And both of them agreed in principle that this could be a halakhically valid solution. But they both said that they would only publicly support Rav Lavi if they both agreed and consented publicly to his psak. When the case came up in Sfat, and Rav Lavi had an actual case to give a psak on, he wrote his psak. But unfortunately, Rav Ovadia Yosef had passed away. So when Rav Lavi turned to Rabbi Goldberg and said, would you please endorse me publicly? Rabbi Goldberg said, I'm sorry. Our agreement was that it takes two to tango, as it were, in this serious decision. And since it's only me, I'm not prepared to go public in support of you. And unfortunately, Rav Yosef was nifta. If you can find another gadol, okay, then okay, I will come out. But Rav Lavi and Rav Goldberg didn't come out in his support. And Rav Lavi was punished internally. He was due to be elected to the Supreme Rabbinical Appeals Court in Jerusalem, but he was told to stay in Tzfat. So there was, if you like, a little bit of personal revenge there too.
It's strange that the one who punished Rav Lavi was Rabbi Yitzchak Yosef, the son of the...
He was indeed. He was indeed. You have sometimes fathers and sons not quite see the same way. Rav Ovadia, by the way, issued many psakim that his son would never dream of ever, because Rav Ovadia Yosef was a true gadol. Okay, whereas, well, anyhow, I should be careful what I say 2 weeks before Rosh Hashanah.
We understand in here.
Okay, so
look, in other words, I'm not sure that Rabbi Lavi would a second time issue the same in a similar case the same psak.
We'll see. We have yet to see. You know, these could go either way. Either Rav Lavi will say, I'm going to do it because I think it's right, or he can say, I've been burned once, I don't want to be burned again. I don't know. These things are the leeways of choice that, as Jean-Paul Sartre would say, this is how we take responsibility for our actions. Okay, these are the leeways of choice in life. We will see, but it certainly is an example of halachic and rabbinic courage in establishing a new halachic head for the amelioration of the plight of an aguna. And if there is a rabbinic will, then there is a rabbinic way. It's one thing we've learned. That's it. I think our time is up. What we will do next week is we will go into the Chief Rabbi Institution, which is a nice historical and social topic on which to conclude our series in its very inception. But before we have a break for the Tishrei festivals, we're going to be off. The week before Rosh Hashanah, of course, we'll be there, but from Rosh Hashanah until after Sukkot, I'll send out a mail. And so let's get together next week, same time, same place. We'll look at the famous dispute over the chief rabbinate. We'll do one in France in the 14th century, and then the Tashbetz and the Rivash in the 15th century. Talk a little about chief rabbis, and then talk a little about the subject that Shmuley raised, Batei Din, and how they're very different from our concept of formal courts. So I'm going to wish everybody a very good evening. Always we say Besorot Tovot, and hopefully there'll be more peaceful times ahead. And we will wish each other a happy new year next week, all being well, happy, healthy, and peaceful. And thanks to Yael and Mickey for bringing us in on the technical front every week. And that's it.
Okay.
That's it, folks. Bye for now.
Bye.
Bye.
Good evening.
Good evening.
Is it recording?
Stop share.
Bye-bye.
Okay. Bye.
Thank you.
That's it.
And stop recording.